Time as a Weapon. Camp Lejeune Part 2. When Congress passed the Camp Lejeune Justice Act, the message was clear. These cases should be heard quickly and fairly. But instead of honoring that promise, the Department of Justice and the Navy reached for a familiar playbook: contest every issue, file motion after motion, and treat these cases like any other mass tort where delay favors the defendant. Plaintiffs' lawyers have described this as a mountain of redundant, meritless motions. Whatever you call it, the effect is obvious. The more paper the government files, the further into the future real trials and real settlements slip. To be clear, there are rules against truly frivolous tactics. Under Rule 11 of the Federal Rules of Civil Procedure, courts can sanction lawyers who file motions with no legal or factual basis, or who act mainly to needlessly increase the cost or length of litigation. Judges in the Camp Lejeune cases have already rejected some government efforts to slow things down, including a request to effectively freeze the litigation during a government shutdown, recognizing that more delay would fall hardest on aging and terminally ill victims who had already waited decades. But the bar for punishment is high. If a motion has any arguable legal hook, it is usually treated as hardball advocacy, not sanctionable abuse. That may make sense in an ordinary commercial dispute. It makes far less sense when the United States government is litigating against its own poisoned veterans and their widows. What is happening may be technically lawful. That does not make it defensible. It is a betrayal of the promise Congress made to Camp Lejeune families, that, at long last, their claims would be heard while they were still alive to hear the verdict. This pattern is not limited to Camp Lejeune. We have seen survivors of Jeffrey Epstein's abuse fight for years to pierce government secrecy and secure meaningful accountability. We have watched families harmed in immigration detention struggle to get even basic transparency, let alone compensation or reform. Taken together, these stories suggest something more troubling than bureaucratic inertia: a government increasingly comfortable treating the suffering of ordinary people as a public relations problem and a legal risk to be managed, not a moral obligation to be honored. This is part 2 of a 3-part series on Camp Lejeune victims. The next episode asks what these delays mean on the ground and what our government could choose to do differently. Demand justice now. Camp Lejeune victims are dying. Call your member of Congress today.